today we're having a flashback Friday, although it is Wednesday. We do a flashback Friday once a month to respond to some questions that we get that we feel are helpful to most clients who are on the webinar with us. So the first question that we have is about FMLA. When do I start the FMLA process? Well, there are no magic words required to start the FMLA process. If you have an employee who is absent for 3 or more consecutive days and they bring in a note indicating that they need continuing treatment or time off from work needed, you should start the FMLA process. If you have an employee who is about to get warned for attendance for missing work due to illness and appointments, you should start the FMLA process. If an employee mentions a family member's illness or tells you that they or their co-parent are pregnant, start the process. The DOL requires you to start the FMLA process as soon as you know that there might be a qualifying situation. So when you have a qualifying situation, you must designate immediately. So what if the employee doesn't want to go on FMLA? That's too bad for the employee. The DOL requires you to designate the leave as FMLA. The employee does not have the legal right to say no to it. Sometimes employees want to save up FMLA for something they're expecting later in the year, but the DOL does not care about that. Sometimes you may think you're being sympathetic and giving them a general leave until they get better. If you do this, they still have 12 weeks of FMLA hanging on the line. So if you do not designate in a qualifying situation and you just let the employee take some leave to be a good employer, when you feel the employee's been gone long enough and you're ready to terminate the employee for being out too long, the employee will become eligible for another mandatory 12 weeks of leave under FMLA just because you didn't designate it at the start of the need for leave. So you could say, well, we'll give you a general leave, we'll give you time off, and it could be an FMLA qualifying absence, and you don't designate FMLA because you don't want to go through the process or you don't want them to run out. Well, then you, at the end of the general leave, when you want to say, it's too long, there's still that FMLA that they get to take. If an employee refuses to bring in the certification of healthcare provider, but you know for a fact that they are sick and cannot work continuously, you can designate without the certification and start counting hours against their FMLA entitlement. So question 2, employees, what are the concerns with terminating a worker over age 40? Well, employees age 40 and older are protected by the Age Discrimination in Employment Act, the ADEA. If you are going to terminate a worker age 40 plus, you need to take a good look at why. If management is saying they need some fresh new blood to energize the company, or if they're saying older workers aren't as up to date on technology, or they have the concerns about the healthcare costs for older employees, stop. These are clear statements of age discrimination, and if a 40 plus year old employee sues you for violating the ADA, these statements are going to put you in the ground. So remember, all of your internal communication is discoverable in a lawsuit. The jury will say what you've been saying, internally about letting this person or people go. If the desire for fresh new blood does not excuse you from discriminating against an older worker, and if you bring new technology into the workplace, you must train your older worker. You can also not set up a mandatory retirement age in most industries, and you cannot require workers to quit or be terminated when they hit that age. So the best way to protect yourself against an age discrimination lawsuit is with a separation agreement in which you pay severance to an employee in exchange for that employee giving up all their rights to bring a claim against you. Separation agreements with employees age 40 plus have specific requirements that are not required in a separation agreement for a younger employee. You must make sure they know that they have the right to have the agreement reviewed by attorney and that they have thoroughly reviewed the agreement and had an opportunity to ask questions. There are some other requirements. You must give an employee who is 40 plus at least 21 days to review the agreement and 7 days to rescind the agreement after they have signed. Now, the employee can waive the 21-day period and sign the agreement sooner, but they cannot waive the full 7-day rescission period after signing. So even if they want the money right away, you do have to give them that full 7-day rescission period after they sign the agreement. If the 40 plus employee is signing the severance agreement as part of a mass layoff, you must give them 45 days instead of 21 to review the agreement. You must also provide the Older Workers Benefit Protection Act notice, which lists the departments and positions that were eliminated, the ages of the workers that were selected to receive the severance package, and how many workers remain in that department and positions. We have an OWBPA notice template that specifically complies with the law that you can use. If you are a client of ours, we can provide it. Just ask in the portal. If you are not a client, again, please email info at myHRcounsel.com, and we can give you more information about that. So question 3, remote work. What do you need to know about hiring a remote employee who works and lives in another state? The first thing you need to do is check with your attorney. So it's likely you will have to register to do business in the state in which the employee is performing the work. You need to familiarize yourself with all of the laws in the state in which the employee is working, including paid sick leave, family medical leave, harassment training, drug and alcohol testing laws, and many others. So that employee is an employee of the state in which the employee is performing work, and all of the laws of that state apply to them. So if you're operating in a state that does not require sexual harassment training, but the state in which your employee is working does require that training, you will have to provide harassment training to that employee. If your state of operation does not have a paid sick leave law, and the state in which the employee is working does have one of those laws, you must make sure that the employee is accruing and being allowed to use paid sick leave. Taxation. Taxation can be complicated, so the employee will have to file state taxes in the state in which they reside and work. You may also need to withhold in your state, and the employee will get a credit against the taxes they paid in your state when they file their tax return in their home state. There are a lot of moving parts on this, however. Some states have reciprocity, in which paying taxes in one state cancels out the tax obligation in a reciprocal state. Some states do not have a state income tax. Some states have agreements with other states in which remote employees can be singly taxed if they work for, in a specific state for a company in another specific state. This is all going to depend on state law. We can assist you with this, but a CPA or a tax advisor is also advised in dealing with this situation with the taxation of remote employees. Some states require reimbursement of all necessary business expenses. If the state you are operating in does not require that, but the state where the employee is working does require that, you will need to reimburse the employee for all necessary business expenses. So remember, a remote employee's workplace becomes your workplace. If they're injured in their home office, it can be a workers' comp injury for you. So it helps to request a video tour of the employee's home workspace and make sure that everything is physically and ergonomically safe. And you should make sure that the employee is covered by your workers' comp policy as well. So question 4, this is a good question for right around the holidays. Can we give employees gift cards for bonuses or holiday gifts? Employers often think, oh, if I give them cash, I'm going to have to put it as part of their taxable income. But if I get them a gift card, that's just a gift card and it doesn't count because it's not money. You can give employees gift cards as a bonus or for a gift, but gift cards are considered cash under IRS rules, and the value of the gift card will be considered part of the employee's W-2 earnings. In addition, a bonus is taxed at the flat 25% rate. So if you give your employee a $100 gift card, they are paying taxes on it and really only receiving $75 to spend. Discretionary bonuses like holiday gifts, thank yous for covering some shifts, employee of the month, uh, are not included in the regular rate of pay for overtime purposes. But if you are giving gift cards for non-discretionary bonuses like sales goals and attendance awards, even though they are not being included in the regular rate of pay for overtime purposes, they are still cash compensation and taxed at the flat bonus rate by the IRS. So sometimes employees can feel cheated when they get a $100 gift card and go out and spend it all and then find out they have to pay the higher tax rate on it and really only got $75 to spend and have to make up the $25 in taxes. One way to avoid this is to true up the bonus, where you give an employee a bonus of a certain amount on the books for tax purposes and end up having the employee's actual take-home bonus be the amount on the gift card. Again, you can ask your CPA or your tax advisor about this and the tax implications of doing this. Something like giving your employees turkeys on Thanksgiving or something else of nominal value would not be included in the employee's taxable income. However, gift cards are always considered cash and the value is always taxed and included in their W-2 income. So question 5, and this is one I've heard recently. Can we give employees bonuses to cover the cost of their own healthcare premiums when when employees have marketplace plans and you don't offer group health benefits? First, make sure that you are absolutely certain that you do not have to offer group health benefits under the ACA. Employers with 50 or more full-time or full-time equivalent employees must offer affordable health care coverage to at least 95% of their full-time employees. And full-time is defined as 30 or more hours per week or 130 hours per month. So if you meet that, it's not a question as to whether you get to offer group health benefits. You are required to do so. If you do not fall into that category but want to help your employees pay the marketplace insurance premium, bonuses are not the way to go. Generally, the best way to do this is to set up a health reimbursement arrangement. The most common arrangement for small employers who are facing budgetary concerns is called an individual coverage health reimbursement arrangement, or an ICHRA. With an ICHRA, the employer sets a budget for reimbursement. The employees choose their health plan and the employer reimburses them on their paycheck. But wait, this is a very complicated area of law, and you are going to want to sit down with your benefits broker, a tax advisor, or an attorney who has expertise in this area before you try to implement this yourself. So just to be clear, offering bonuses to employees that they could use for anything, but telling them they have the option of putting it towards their marketplace and insurance premiums is not the way to go. The employee is going to get taxed at the flat bonus rate for the bonus you give them. meaning they will get less than what you are trying to give, and it will not necessarily go toward health insurance. Question 7, and I am going to stop here with question 7 because we are limited, or excuse me, question 6, because we are running out of time. I'll go through this one quickly, and the questions we did not get to will be in a following Flashback Friday webinar. So background checks, can I share the results? This is an unequivocal no. I hear this a lot from staffing agencies. No. You can provide your client with an attestation that every worker you are sending over has passed the background check specifications that they have laid out. You cannot send the actual results. If you are a school or a childcare agency, you're a mechanic that works on luxury cars, and the parents or the customers want to see the actual results of a background check, you have to say no. If you have an employee who leaves your franchise to go to another franchise owned by someone else, and you are part of an association of franchisees or just friends with other franchisees, you cannot share any details. So this is for several reasons. One is that as the employer, you are responsible for protecting the employee's privacy. Once you let go of the employee's background information, you have no control over where it goes, and you could be hit with an invasion of privacy claim. The second reason is that companies that compile and report background checks are called consumer reporting agencies, or CRAs. The federal government has very strict requirements for CRAs, and if you are operating a CRA without following all of those requirements, you could be penalized by the federal government. So if you get a background check report and you start distributing the results to third parties, you are acting as a CRA. But of course, you're not set up to follow all the federal government requirements to be a CRA. So basically, if you're distributing background information and the feds see you acting as a CRA, you will get in big trouble for not meeting all of the CRA requirements. The third reason is that if the information is incorrect and you tell a third party that the employee committed a crime, you could face a defamation suit. So I'm going to stop there. I realize we have one more question here, and but to keep us on time with the 15-minute webinar, I am going to move question 7 to a future webinar, although you will get the deck and see the question. But as far as answering the question, I'm going to move that to our next Flashback Friday. So thank you all. In summary, as you can see, there's variations from state to state with many of the questions that we receive. There can be differences between federal and state law. Some of the answers to questions are very straightforward. Others require more interpretation and nuance. The best course of action is to run your questions by us. If you're already a client, shoot us a message through our Ask HR portal. If you'd like to sign up for our services, check out our website, or go email info@myhrcounsel.com. So thank you all for participating in the webinar. I hope you all enjoy the rest of your day.